In the previous video of this series, we looked at the element of murder and what the defendant would need to satisfy in order to be convicted of this offence. But there are two special defences to murder, and both of which will reduce his charge of murder to voluntary manslaughter. These two defences are loss of control and diminished responsibility. Our friend here is rather old and is suffering from depression and paranoia, so he'd likely be able to rely on the defence of diminished responsibility. But what's the criteria for diminished responsibility? Luckily for us, diminished responsibility was created by Parliament. Or maybe not so lucky, depends on how you look at it. Section 2 of the Homicide Act 1957 is replaced by Section 52 of the Criminal and Justice Act 2009 states the following. Subsection 1A. A person who kills or is party to the killing of another is not to be convicted of murder if the defendant was suffering from an abnormality of mental functioning, which A. arose from a recognized medical condition, B. substantially impaired the defendant's ability to do one or more of these two things mentioned in subsection 1A, which is to understand the nature of the defendant's conduct, to form a rational judgment or exercise self-control. And then C, it should provide an explanation for the defendant's act and omissions, doing or being party to the killing. So let's start off with the abnormality of mental functioning. In the case Byrne, Lord Parker defines it as a state of mind so different from that of the ordinary person that the reasonable man would term it abnormal. This includes situations where a person has an irresistible impulse or an inability to control physical actions or act rationally. Let's look at A, the recognized medical condition. So the abnormality of mental functioning must stem from a recognized medical condition. This covers both physical and psychological conditions, and the accepted list of medical conditions is from the World Health Organization, the WHO, and the American Psychiatric Association, DSM, of mental disorders. If condition is not stated in one of these two books, these two lists, then there wouldn't be a recognized medical condition and the defendant would satisfy the test of diminished responsibility. Here's a nice little table of common recognized medical conditions you'll likely find in the exam. So feel free to familiarize yourself with them as you may come across one. Next, 1B. There must be a substantial impairment of the defendant's ability to understand the nature of their conduct, form a rational judgment, or to exercise self-control. So to understand their conduct, this is where the defendant is in an automatic state and they don't know what they're doing. As for the rational judgment, this is where the defendant, he may know what he's doing, but he's unable to think rationally and he's unable to determine what is right and what's wrong. This is where the defendant is suffering from an irresistible impulse or cravings and that they can't control their physical acts, like in the case of Byrne. Now, I know what you're probably thinking. What does substantial mean? Right? Well, don't worry, the judge in RV Goals has your back. So usually the judge doesn't need to define substantial for the jury, but if the jury doesn't understand the word, then what the judge should say is the impairment must be more than trivial to be substantial, that not all impairments more than trivial will pass. And then as for 1C, the abnormality of mental functioning must provide an explanation for the defendant's acts or omission in doing or being party to the killing. So if the defendant would have killed despite the abnormality, the defense would not be available to him. In the case Khan, it was demonstrated that just because a defendant has a recognized medical condition and abnormality of mental functioning, he passed all the other stages, but that doesn't mean he can automatically have the right to the defense of diminished responsibility. The Court of Appeal in this case, held that it was up to the jury to decide, based on the facts they were given, as to whether the defendant's mind was impaired. So the jury will consider all the evidence, the medical, factual, all circumstances of the case, and they'll decide whether the defendant's mind was impaired at that moment. What's important to note here is that when answering a question, you must evaluate the scenario and weigh the evidence and make an educated assumption as to what the jury would decide. Also, a little bonus, if the defendant kills while intoxicated, the general temporary effects of intoxication aren't considered sufficient to form an abnormality of mental functioning. This is seen in the case of Dodds. However, if the defendant has a long-term history of alcohol abuse, then it may be relevant to the defense. It will be something the jury may consider. And that about wraps it up for the test of diminished responsibility. Next up will be the loss of self-control, which will also lead to a reduced charge for murder, voluntary manslaughter. To remember this test, I recommend making a flowchart and listing all the key informations of diminished responsibility. But don't worry, I've listed all the key information and cases in the description below. And that's about all I have today for you folks. I'll see you in the next video.